Hi, I'm Whitney Prout, Policy and Compliance Counsel with the California Apartment Association. In this video, I will provide you with a summary of SB 91, the bill recently passed by the California legislature that establishes a new state rental assistance program and extends California's statewide eviction moratorium. To help explain this new law, I'm joined by my colleague, Embert Madison, who is also Policy and Compliance Counsel for CAA. Before we get started, if you're not familiar with CAA, we are the California Apartment Association, a trade group representing owners and managers of rental housing in California. We serve the rental housing industry by representing the interests of the industry in legislative, judicial, and regulatory forums, helping our members understand and comply with the law by offering educational materials, forms, and other compliance resources, as well as offering services such as insurance and resident screening that members need. If you're interested in learning more about membership, visit our website at caanet.org.
In this video, Whitney and I will give you a brief overview of SB 91. However, it's important to understand that this video will not be providing legal advice. While CAA strives to provide accurate and timely information to assist its members, this video only offers general information and is not intended as legal advice. For legal advice about your specific situation, you should contact and hire an experienced attorney. This video is going to give you a brief introduction, and summary of SB 91. It is not a comprehensive overview of every provision in the new law or a webinar about how to comply with the new law. If you want more information about the specifics of this law, you should register for one of CAA's one-hour webinars that will cover the law in more depth. Visit caanet.org/CTRA for a link to register for that webinar. So Whitney, what is SB 91?
SB 91 is a bill that was passed by the California legislature on January 28, 2021, and signed into law the very next day by Governor Newsom on January 29, 2021. It took effect immediately upon being signed by the governor. And in brief, the bill does two key things. It extends California's statewide eviction moratorium and creates a new rental assistance program. More specifically, there are really four key components to SB 91. First, as I mentioned, it extends the COVID-19 Tenant Relief Act. That is the statewide eviction moratorium that was enacted back in August of 2020 by Assembly Bill 3088, as some folks may remember. It extended that law through June 30th, 2021. Second, SB 91 makes changes to lawsuits that landlords bring to collect unpaid COVID-19 rental debts, and we'll talk about those specifics in a little bit. It also enacts some new tenant protections related to the COVID-19 pandemic. And then last, but most certainly not least, it creates a new state rental assistance program to help both landlords and tenants with the large amount of outstanding rent in the state. So as we saw on the last slide, the first thing SB 91 does is extend until June 2021 the COVID-19 Tenant Relief Act, or Citra for short. You'll hear us use that acronym throughout this webinar, Citra. We're talking about the COVID-19 Tenant Relief Act, that eviction moratorium. So this is the law that, among other things, requires landlords to give a 15-day notice rather than a 3-day notice for unpaid rental payments due between March 1st of 2020 and now June 30th of 2021. You might recall that previously Citra only applied to rental payments due through January 2021. Again, now that's been extended to June 2021. Citra is also the law that allows a resident who is unable to pay their rent as a result of a COVID-19 related hardship, such as a loss of income, to avoid eviction for non-payment by submitting to the landlord a declaration of COVID-19 financial distress. Again, that protection will now apply through June of 2021 under this new law. Similarly, Citra previously required residents who submitted one of those COVID-19 financial distress declarations to pay 25% of the missed rental payments due from September of 2020 through January of 2021. They were required to make that 25% payment by January 31st, 2021. The deadline to make that 25% payment, again, now extended to June 30th, 2021. In addition, that 25% payment due on June 30, 2021 also now applies to the rental payments due between February and June of this year, 2021. And then in addition, SB 91 also continues the expansion of AB 1482 just cause requirements. That was originally enacted as part of Citra back in August. It was set to expire come February, again, has now been extended through June. In short, what this means is that the landlord must have and state in any notice of termination of the tenancy the reason that they are terminating that tenancy. The reasons the landlord can evict under this law are generally limited to those that are specified in the Tenant Protection Act of 2019, also known as AB 1482. And those are reasons like the resident has continued to violate their rental agreement after having been given a written warning to stop doing so, or if the landlord is removing the property from the rental market. Now, this next piece is very, very important. I know that we're going through a lot of information, but if you take nothing else away from this video, get this. Part of the extension of Citra that was made by SB 91 is a requirement for landlords to send a notice about the changes in the law to all of their residents who owe one or more rental payments due since March of 2020. Due specifically between March of 2020 and February of 2021. If they owe all or any part of one of those payments as of February 1st, you have to send this notice. So that would include residents who you've not served any sort of 15-day pay or quit notice to. It would include residents that you did give a 15-day pay or quit notice to, but they didn't return that Citra declaration. And even those folks who received a 15-day notice previously and did return a Citra declaration to you. Any of them, if they owe any money due since March of 2020, you need to send this notice to them, and you need to send it to them by February 28th, 2021. Remember that date. The content of the notice is specified in the law. CAA has created a form you can use to comply with this requirement. It is CAA's informational notice of COVID-19 Tenant Relief Act extension and new rental assistance program. That's form CA 405. I know that's a mouthful, but you can see it, a little preview of it there on the screen. You can use this notice to comply with that requirement. You cannot serve any new 15-day notices until you have complied with this requirement, and failure to meet that February 28th deadline may affect your ability to evict a resident who does not comply with Citra. So it's really crucial that you send this notice out and that you send it out on time. Because of the importance of this requirement, CAA is offering this form for free to members of the public. You do not have to be a CAA member to access this form, though of course we do encourage you to join the association. So with that, I will pass it on to Embert to talk a little bit about what changes the law makes dealing with debt collection lawsuits. Embert, over to you.
Yeah, definitely. The second key component of SB 91 includes the changes that SB 91 made to the requirements for suing a resident for unpaid COVID-19 rental debt. And when we say COVID-19 rental debt, that means rental payments due during the period covered by Citra, which is March 1st, 2020 through June 30th, 2021. So we will repeat COVID-19 rental debt, and that means rental debt that has not been paid that accrued through March 1st, 2020, from March 1st, 2020 through June 30th, 2021. So you may recall that when AB 3088, aka Citra, was adopted in August of 2020, it expanded the jurisdictions of the small claims court to allow landlords the option to bring any claim for unpaid COVID-19 rental debt in small claims court, normally Absent Citra, this would not be allowed. And this change in Citra even allowed a claim to be brought in small claims if the amount sought is more than what is typically allowed in small claims court, and even if the landlord has previously brought 2 or more claims within the past year. Citra also mandated a delay on bringing these cases until March 1st, 2021. SB 91 maintains the expanded jurisdiction of small claims court, but extends the delayed date on which such cases may be brought to court until August 1st, 2021. So previously, before SB 91, these cases could be brought in small claims court as of March 1st, 2021, but now that deadline has been extended to August 1st, 2021. In addition, SB 91 also institutes a delay on bringing cases in regular civil court, i.e. not small claims court, to recover COVID-19 rental debt until July 1st, 2021. It also places cases already filed on hold unless the case was filed before October 1st, 2020, and the resident being sued would not have qualified for rental assistance under the new state rental assistance program. We haven't brought up the new state rental assistance program yet, but we will talk about it shortly. The main thing to understand for this part of SB 91 is that the state rental assistance program is available to lower income Californians. So the only pending cases that will be allowed to continue will be against higher income individuals. In addition, when you're filing either a small claims case or a regular case in regular civil court that seeks the recovery of COVID-19 rental debt, the landlord will now be required to attach documentation to the lawsuit that establishes that the landlord did all of the following 3 actions: made a good faith effort to investigate whether there's any governmental assistance available to that resident, sought governmental assistance for that resident, and number 3, cooperated with the resident's efforts to obtain rental assistance from any governmental entity or third party. So now a landlord has to do these 3 things before they file their small claims case or regular civil court case for the recovery of COVID-19 rental debt. The final change made to lawsuits to collect COVID-19 rental debt has to do with the amount of attorney's fees a prevailing party can be awarded by the court. This means that if your rental or lease agreement with the resident entitled you to an award of attorney's fees in the event you had to go to court, the amount you can recover is limited by SB 91. The court is limited to award $500 in attorney's fees in uncontested cases. Uncontested cases are those in which the resident does not file a response to the lawsuit and the landlord gets a judgment by default. In contested cases, where the resident does fight the case, the award is limited to $1,000. This being said, even if it is a contested case, if it is unusually complex or time-consuming, the court can award attorney's fees in an amount that exceeds these limitations. For example, let's say the resident conducted extensive discovery, filed many motions, and demanded a jury trial. In such a case, the judge would have discretion in whether to allow an award of attorney's fees greater than $1,000. Finally, it is important to note that this section of law does not entitle either party to an award of attorney's fees. An award of attorney's fees would only be proper if the rental or lease agreement allows such a provision. And if so, under SB 91, that amount of attorney's fees recoverable is limited.
Thanks, Embert. In addition to those changes in the law that Embert just talked about, as well as the extension of the eviction moratorium, SB 91 also included several new tenant protections related to the COVID-19 pandemic. The first 2 protections that we are going to talk about only apply to those residents who have submitted a declaration of COVID-19 financial distress. Again, we talked about this earlier. That's the declaration form residents would return to the landlord after being served with a 15-day notice to gain the protections of Citra. For those residents who have submitted one of those declarations, SB 91 states that the landlord cannot charge or attempt to collect late fees. This means you cannot charge new late fees, but you also cannot try to collect late fees charged prior to SB 91 taking effect, which have not yet been paid. Second, again, for those residents who have submitted a COVID-19 financial distress declaration, the landlord cannot increase or charge new fees for services previously provided without charge. For example, if parking was previously included in the rent for one of these covered residents, you could not start charging a new fee for parking. Likewise, let's say you were already charging a fee for parking of $20 a month. Again, for those residents that have submitted one of these COVID-19 financial distress declarations, you could not increase that fee. The second set of protections apply to all residents, regardless of whether they have submitted a Citra declaration. So the first rule that's applicable to all residents deals with how the landlord applies a payment received from a resident. SB 91 says that the landlord cannot apply a monthly rent payment to any COVID-19 rental debt. And you'll recall Embert told us COVID-19 rental debt are those amounts that came due between March of 2020 and that will come due up through June of 2021. So you cannot apply a monthly rental payment to that COVID-19 rental debt other than the prospective month's rent, unless the resident has agreed in writing to allow the payment to be so applied. Second, the landlord cannot apply a security deposit to satisfy a COVID-19 rental debt during the tenancy unless the resident has agreed in writing to allow the deposit to be used in that manner. You could still use the security deposit to offset that unpaid rental debt after the resident has vacated, consistent with the pre-existing law dealing with security deposits, but you could not unilaterally use it during the tenancy to offset that debt. Lastly, SB 91 prohibits a landlord, resident screening company, or other entity that evaluates applicants on behalf of a landlord from using an alleged COVID-19 rental debt as a negative factor for the purpose of evaluating a prospective housing application or as a basis for refusing to rent a dwelling to an otherwise qualified resident. Now that's a lot of words. Essentially what that means is you cannot use a COVID-19 rental debt as a negative factor in your screening criteria. So you couldn't deny an application to someone who otherwise meets your screening criteria simply because they owe one of these COVID-19 rental debts, and you couldn't use it, for example, to require a higher security deposit or to require that resident to have a guarantor as a condition of their application being accepted. And then third and the final new tenant protection created by SB 91 applies to all residents for a time and to some residents permanently. And we'll explain how that distinction is made in just a moment. First, let me explain what the protection is. It prohibits the sale or assignment of COVID-19 rental debt. Again, remember, those are those amounts due between March of 2020 and June of 2021 for all residents until July 1st of 2021. What this means in practice is that the landlord cannot turn over unpaid COVID-19 rental debt to a collection agency or other entity that pays the landlord some percentage of the unpaid debt in exchange for that collection agency or other entity having the right to pursue the resident for the unpaid amount. This ban is lifted after July 1, 2021 for some residents, but not for all of them. The ban on sale or assignment of that debt is permanent with respect to residents who meet the eligibility criteria for the rental assistance program that we're going to talk about later in this video, but it is lifted with respect to other residents. We'll talk about the new rental assistance program next. As Embert mentioned before, the main thing to understand for this specific situation is that the rental assistance program is going to be available to lower income Californians. And so the debt sales and assignments that will be allowed to continue after July 1st are only going to be for those higher income individuals. Now, arguably, the most important part of SB 91 is the creation of this new state rental assistance program that we've referenced a couple of times. Embert, can you tell us about the program?
Definitely. So SB 91 uses the money allocated to California from the federal government as part of the recent federal stimulus bill to create this new rental assistance program. To be eligible to receive rental assistance funds, a resident's household must meet all of the following three criteria that I'm going to describe. First, at least one person in the household either qualifies for unemployment benefits or experienced a reduction in household income, incurred significant costs, or experienced a financial hardship due to COVID-19. Second, at least one person in the household can demonstrate a risk of experiencing homelessness or housing instability, which may include any of the following: a past due utility or rent notice, or an eviction notice, or an unsafe or unhealthy living conditions, or any other evidence of such risk of homelessness or housing instability as determined by the department that is instituting the rental assistance program. And thirdly, household income at or below 80% of the area median as determined by the U.S. Department of Housing and Urban Development. So to summarize, in order to be eligible for this rental assistance program, a resident's household must meet all three of those criteria that I listed. And simply meeting the criteria listed does not necessarily mean that a resident will be awarded rental assistance funds. The state rental assistance program will prioritize funds first to eligible households with a household income of less than 50% of the area median income. Then to communities disproportionately impacted by COVID-19 as determined by the department. And finally, to all other eligible households with a household income less than 80% of the area median income. So as you see here on the slide, that the rental assistance funds will be given out in 3 rounds. The first for residents with income of less than 50% of the area median income. Secondly, communities disproportionately impacted. And third, any remaining money to eligible households that have that 80% or less of AMI. The state rental assistance program allows a landlord to apply directly to the department for payment of rental arrears. This is important to note, so landlords, please listen up. The application process will require the landlord and the resident to work together, as eligibility for the funds is based on the resident's circumstances. For example, how would a landlord even know that a tenant's household is at 50% of the AMI? That's why the landlord and the tenant has to work together where possible. While we don't know the exact process for applying for the funds, it is likely that information such as proof of income will have to be provided by the residents for the application to be processed. The application period is required to begin by March 15, 2021. The program limits the amount of assistance a household can receive based on a percentage of the past due rent for the specified period. In other words, the program doesn't tell us how much money a household will receive. Instead, it gives us a percentage of the past due rent that the landlord can collect based on what the tenant owes, whether the tenant owes $1 or $100,000. Specifically, an eligible household may receive up to 80% of their unpaid rental debt, right? And our unpaid rental debt is that rental debt which accumulated from April 1st, 2020 to March 31st, 2021. Whether it's $1 or $100,000, a landlord is only eligible to receive, so long as that landlord applies, up to 80% of that unpaid rental debt. Additionally, if the landlord does participate in this rental assistance program, it is required to waive the remaining amount owed for that rental period. If a landlord chooses not to, or refuses not to apply to the state rental assistance program, a member of the eligible household may then apply for assistance. In this scenario, the amount of rental assistance will be limited to 25% of the eligible household's unpaid rental debt. Big note here, landlords, if you choose not or refuse to apply for the state assistance program, please note that the tenants or your residents will be able to apply to this program, but they will be limited to getting up to 25% of their rental amount owed, right? So if landlords apply, it's up to 80%. If tenants, it's up to 25%. Big distinction there. Please also be aware that SB 91 created a rule that allows the court to reduce the damages awarded to a landlord who sues a resident for COVID-19 rental debt if the court determines that the landlord refused to obtain rental assistance from and the resident met the eligibility requirements of the state rental assistance program and funding was available. What that all means is that if a landlord decides to sue a resident for COVID-19 rental debt, the court will look to whether the landlord refused to obtain rental assistance from the state rental assistance program and whether the resident met the eligibility requirements and there was money available for that tenant, i.e. did the landlord willfully not try to receive the funds that are available under the state rental assistance program. As you can see then, it is extremely beneficial for a landlord to be proactive and apply to the state rental assistance program because the amount of rental assistance will be much higher when the landlord participates. And even if the landlord refuses to participate, that refusal will be taken into account if the landlord sues the resident for COVID-19 rental debt. Whitney, where can landlords look to if they want to find more information about SB 91?
So to find more information about SB 91, CAA has set up a dedicated compliance page to all things SB 91. You can find that on our website, caanet.org/Citra. That's CTRA, short for the COVID-19 Tenant Relief Act. On this page, you will find resources including forms to comply with the new law, like, and I'm going to plug it again here, that notice that has to go out by February 28th, 2021. If you're a landlord in the state of California and a resident owes you money, do not forget to send that notice. It is available for free on our webpage, caanet.org/Citra. You'll also find on that website, again, a free frequently asked questions document that will tell you about more information about this law. Believe it or not, that summary that we just gave you is really only skimming the surface. You can also find a link to register for our webinar that will go into this law in more detail on that page, as well as much, much more. So with that, again, go to caanet.org/Citra. And Embert, thanks for joining me.
Thank you, Whitney. It was my pleasure.
All right, thanks for watching, everyone.